Ladies and gentlemen, I have already told you about unlawful agreements, and I have also spoken to you about the classification that has to be done with regard to study of unlawful agreements. You have got to study unlawful agreements from the point of view of illegal transactions and from the point of view of immoral and from the point of view of public policy. So these are all the various sections under which we have got to study transaction arising out of illegal agreements. Sale of office and corrupt influence, these are the two factors that will come under illegal agreement. And so far as immorality is concerned, I told you it is based ethically on principle, and in that connection, so far as law is concerned, it will actually take into account whatever transactions that is considered to be beneficial to society and beneficial to community, that alone will be encouraged, and whatever is completely detrimental to society will be discouraged. So in that connection, we saw under immoral transactions two aspects, namely any sort of agreement which has got for its consideration future illicit cohabitation, and any sort of transaction that which paves the way for separation between husband and wife. So these are matters which are dealt with under these immoral aspects. And then the other one, last category under which we have to study the various transactions arising out of agreement which are considered to be opposed to public policy. Now, first let us take the sale of office and corrupt influence. So far as sale of office, I have told you one case with regard to a peon who is a senior, who is about to retire, entering into a contract with his immediate subordinate that he will try to retire as early as possible, and by applying preparatory leave before retirement, on account of which the junior peon said that he will compensate the senior peon, and then they entered into an agreement. That agreement cannot be enforced because sale of office is not permitted. One cannot sell the office that have been assigned to him. So any office mixed with authority that has been bestowed on him cannot be bartered, cannot be completely sold or exchanged for any other pecuniary obligations. So that is there. Now, I want to explain the sale of office. I have explained. What is this corrupt influence? Corrupt influence, any sort, you see, the object of law is not only lawful, but the consideration that is being used for achieving that object must also be lawful. That is why section 10 says, every agreement is a contract provided it is made with free consent by competent parties for a lawful consideration and for a lawful object. Not only object must be lawful, the consideration which paves the means for achieving that object must also be lawful. Even object may be lawful, but if the consideration is tainted with illegality, that becomes corruption. As I already told you, even lawful objects may be accomplished by unlawful means. Not only the means must be justifiable, but the end also must be justified. So these are the two things which you should bear in mind. I will tell you in this connection a very leading case. Parkinson versus Harrison and College of Ambulance. Parkinson versus College of Ambulance and Harrison. That is a leading case. In this particular case, Parkinson entered into a contract with Secretary of College of Ambulance that he should get a title known as knighthood. Knighthood title. So, knighthood title should be conferred only on merit or only on justification that a person has rendered some service to the society. Or he should have done something which is praiseworthy among the people in the society. So, but this fellow entered into a contract with Harrison, who happened to be a secretary of the College of Ambulance, that he should get knighthood title. By entering into an agreement that he would like to pay whatever money that has got to be expended for the purpose of getting this knighthood title. But what happened when the money was not paid, when once Harrison, the secretary of College of Ambulance, got him the title, this fellow refused to pay the money. Then question of liability. Then the question came up before the court. The court said, you cannot actually purchase any sort of title by paying money. Title must be conferred on recognition of merit. Any doctorate degree, apart from being honorary degrees, any doctorate degree cannot be acquired by illegal consideration. You cannot pay money and get degrees. So, this particular case comes under corrupt influence. Sale of office and corrupt influence are discouraged. Then, stifling prosecution and ousting jurisdiction and stifling prosecution. I have already told you about ousting jurisdiction. Ousting jurisdiction means what is lawfully authorized under a particular act. A particular officer has got to exercise an authority means you cannot enter into a contract with those authorities to have it in a different way. That is, strictly you have got to abide by the law. Both the authorities and as well as the private individuals, they have got to abide by the law. For example, ousting jurisdiction, as I said, that means thwarting. Thwarting means you cannot ignore the jurisdiction of a particular authority. As I told you in the case of seller and buyer. Seller is at Bangalore, buyer is at Madras. So when he sells the goods to a person who is residing at Madras and wants the seller to send the consignment through rail or road, and if the consignments are taken delivery of and the money is not paid, now the question arises, where exactly the suit has got to be filed? Should it be filed at Bangalore or should it be filed at Chennai? Now this will be a dispute. Now under the Civil Procedure Code, this has been authorized. Either the seller can actually file a suit at Bangalore or at the place where the defendant resides, namely the purchaser who is residing in Chennai. That will be the proper place where the suit can be filed. So here the cause of action, cause for legal action, where it has arisen, whether it has arisen at Bangalore or whether it has arisen at Chennai. These are the two places. But it is left open to the parties to actually choose the place where they have got to file a suit. That is why invariably the sellers in their order form, they incorporate a condition stating that any dispute pertaining to short delivery or whether it is to defective delivery or damages, the matters pertaining to these disputes have to be settled only at Bangalore, and the Bangalore court alone has got jurisdiction to decide about these issues. So, well, for which the defendant, namely the purchaser, must agree. If the purchaser agrees to the condition and then he purchases the good, then purchaser has got to strictly abide by the condition to which he has been a signatory. So, this is what is known as the jurisdiction that is agreed to or accepted by the parties to the transaction. But it is not left open to the parties to choose the jurisdiction according to their own arbitrary will and pleasure. Supposing the purchaser says, no, seller, you come to Coimbatore, you can also come to Coimbatore, I can also come from Chennai to Coimbatore, let us have the jurisdiction at Coimbatore. It is not left open to the private parties to choose the jurisdiction according to their own desire. The law decides, according to the Civil Procedure Code, whatever that is prescribed under law, you have got to comply with it. That is why Section 29 says that any sort of agreement in contrary or in opposition to the provisions of law, well, that cannot be enforced. For example, the limitation period on a promissory note is 3 years. If you borrow any money on a promissory note, you have got to repay the money within 3 years from the date on which you have borrowed. Now, can you extend it? You can extend it by endorsement on the back of the promissory note. but that is legally it is permissible. But is it left open to the parties under a separate agreement? All right, we will actually extend this limitation period for 5 years. Is it left open to the parties to decide about the limitation period? Certainly not. Any right that is actually given either under the Constitution or under the Act or under any contract, that cannot be bargained and that cannot be waived according to the will and pleasure of the parties unless it is permitted under law. Please understand this very clearly. Constitutional rights. What are the rights that are guaranteed and granted under the Constitution? Fundamental rights. Can you ignore fundamental rights? Can any party bargain with regard to surrendering of fundamental rights? Certainly not. In fact, in a labor dispute, a question arose whether the laborers, do they have a right to strike? Can they actually waive their right to strike? Right to strike is the inherent right of the labor force. The trade union will always have a right to enjoy their privileges. It is not left open to the management to bargain and then purchase those rights or make the trade union to waive their rights. To waive means to give away, to forego the rights. So that is what is known as fundamental right. Right to marry is a fundamental right. So right to speak is a fundamental right. You cannot actually make a person not to speak, not to write. So these are all fundamental rights. And then you have got statutory right. Enactment by the provisions of Constitution, the state has got certain powers according to the state list, and the center has got certain powers with regard to the central list. You have got union list. So the Union Act and the State Act. So these are all what is known as statutory rights. Any rights that are granted under the statute, that cannot also be taken away. That cannot be surrendered by the parties to the agreement. Unless the Act itself permits, unless there is a contrary provision, unless there is a contrary provision, contrary subject to the Act. So, you cannot enter into a contract contrary to the provisions of Partnership Act. You cannot enter into a contract contrary to the provisions of the Sale of Goods Act. So, the Act itself says, what are all the transactions you can actually enter into a contract contrary to the law. Subject to the provisions of this Act, you can enter into a contract like this. So unless the Act permits, you cannot enter into an agreement contrary to the provisions of the enactment. Then contract is among the private. So fundamental right that is granted and guaranteed under the Constitution. Statutory right emanating out of the constitutional provision. The contractual provisions are emanating out of the Act, enactment. Unless the enactment provides for separately entering into a contract, you cannot enter into a contract contrary to the enactment. That you should bear in mind. So under section 28 of the Contract Act, you cannot bargain any legal right by entering into a private agreement. So this is what that you should understand. That is with regard to this judicial aspects. You cannot bargain the right and then forego your right. That is with regard to judicial aspects. Then the next important thing is public policy. As I told you, public policy is very difficult to define. The judges are there only to expound law and not expand law. Under the public policy, we have seen now, just now we have seen the sale of office and corrupt influence and stifling prosecution and what is known as ousting jurisdiction. What is stifling prosecution? Preventing prosecution being conducted. As I told you yesterday, you just enter into a bargain or under an agreement with a doctor that you should not come and depose evidence. Well, that is stifling, you are preventing prosecution. So, any sort of indulgence with regard to preventing prosecution being conducted, it is opposed to law. Now, I will try to explain to you some of the leading cases with regard to stifling prosecution. Now, under the stifling prosecution under judicial proceedings, you have got certain important cases. These cases are actually based on two principles. That is, ex turpi causa non oritur actio. Law discourages people from entering into illegal agreements which arise from the base causes. Secondly, in pari delicto potior est conditio non defendentis. That is the case of Pierce versus Brook. As I told you, a coach builder, knowing fully well that the woman who has entered into a contract with a coach builder is leading an immoral life and making use of the coaches for immoral transactions and business, then he actually gave a coach on installment basis to collect the money on equal installment. When some of the installments were not paid, the coach builder filed a suit and the court said you cannot enforce it because you knew pretty well for the purpose for which the coach is being used. That particular maxim, impari delicto potior est conditio non defendis. You see, in cases of equal guilt, the position of the defendant is safer than that of the plaintiff. That is what it says. Now, the second aspect with regard to this judicial matters which are opposed to public policy, under that you get invoking the blessings of God, under which agreements are actually entered into. You find in one case Bhagavan Dutt Sastri versus Rajaram. Bhagavan Dutt Sastri versus Rajaram. A particular person, a litigant, he happened to be a litigant. Litigant means one who has got a case in the court. Now he entered into an agreement with a pujari, with a priest, that some sort of interference by mysterious force should actually be used in order to make him to succeed in his case. So this is, in other words, it is known as a type of black magic. Can you use black magic for the purpose of succeeding in the case? In this particular case, what happened? This litigant, a person who had a case pending before the court, he entered into a contract with a black magician and wanted some external force or mysterious force to be used on the judge to write the judgment in favor of the particular litigant. Now, is it possible? Then it so happened by coincidence that particular person who entered into an agreement with the black magician, he succeeded. And the black magician said, as promised, you have got to give this money to me. Then he said, you use the same force against me also to get the money. Then he filed a suit. Then the question arose whether the suit can be enforced. The court said it cannot be enforced because this is against law. If everybody start using black magic force for the purpose of succeeding in the case, then there is no need for the judge to dispense with justice. Then the next important thing is, there is another case which was distinguished from use of mysterious force. That is the case of Balasundara Mudaliyar versus Muhammad Osman Sahib. This Balasundara Mudaliyar and Osman Sahib, they happen to be good friends. In fact, this Balasundara Mudaliyar was a devotee of Lord Muruga. When this Osman Sahib had a case before a court, Balasundara Mudaliyar said, I will try to invoke the blessings of Lord Muruga in order to enable you to succeed in the case. And Osman Sahib agreed to it. Yes, I will pay you so much of money. And this Balasundara Mudaliyar said, I am not going to make use of any mysterious forces. I am going to invoke the blessings of God by doing some abhisheka. Abhisheka means by giving bath to Lord Muruga idol with milk, honey and fruit juice and all that. So this Mohammedan gentleman, Muhammad Osman Sahib, agreed for that, and he said, whatever expenses which you incur for performing this puja, I will actually reimburse you. As a consequence of which the puja was performed and Muhammad Osman Sahib succeeded. Now the question arises, when this Osman Sahib never paid the money, Balasundara Mudaliyar naturally filed a suit. Then here the court enforced it because it is for the purpose of benefit for the other litigant, namely Muhammad Osman Sahib. If I am praying that all of you should actually secure more than 60%, in Contract Act and I am actually invoking the blessings of God and I spend some money lawfully and legitimately for performance of puja and all that, well, that is not opposed to law. That is not detrimental to any person or to society. I am only invoking the blessings of God for the purpose of doing good things for you. Well, the court said that is a fit case where the Mohammedan gentleman Osman Sahib has to reimburse this Sastri who has actually incurred some expenses for performance of puja, that is namely this Balasundar Muraliya. So, these are the matters which you should understand. Then, under English law, maintenance and champerty are not very much encouraged. Maintenance means what? Maintenance means promotion of litigation. Champerty means sharing litigation. Promotion of litigation and sharing litigation are completely discouraged. If anybody who has absolutely no interest when he is not a party to a litigation, how can you actually encourage the other party? All right, you file a suit, I will actually support you. Seeking financial assistance for the purpose of filing a suit is different from actively encouraging a person. No, if he is keeping quiet, if he is not willing to file a suit, the other fellow, I will give you the money, you come on, you file a suit against your brothers, we will actually partition your property. Supposing a fellow who is not at all interested in the party's welfare, and if he is saying, all right sir, you file a suit sir, I will encourage you to partition this property, I will give you the money, you file a suit. Supposing he says, this is what is known as encouraging litigation, that is maintenance, which is not valid. If anybody gives money for the other party to file a suit, to pay court fee for the purpose of filing a suit and all that, well, that is not considered to be unlawful or illegal. But other thing is champerty, sharing litigation. Sharing litigation is this party is giving money to the other party to file a suit for the purpose of sharing any proceeds that may arise out of the litigation. For example, what best example I can give you, motor accident claim tribunal cases. Invariably, in MACTOP, motor accident claim tribunal cases, if any person involves himself in an accident and he loses his limb, the court actually awards compensation to an extent of 50,000 rupees, in which the advocate will say, I will get you 50,000 rupees, but you should give me 30,000 rupees towards my share. Now, this is what is known as sharing litigation, sharing proceeds of litigation. That is also against law. So, you must understand that is sale of office and corrupt influence. And so far as judicial aspect is concerned, ousting jurisdiction and ousting jurisdiction, that is one thing. And the other thing is ousting jurisdiction and stifling prosecution. Both these things are discouraged. Then let us come to personal freedom. Personal freedom. As I said, you cannot enter into a contract to make a person to lose his personal right or freedom. Now, in that aspect, we have got 4 categories under which we have got to analyze the subject. Now, right to marriage. Every person who is born as a human being, he has got a right to marry according to the system, according to the religion, and according to the custom which authorizes him to marry. So, nobody can prevent the other fellow from marrying, except he must be a major under the Indian Majority Act of 1845, or if there are no guardians, then under the 1890 Act, he should have completed the age of 21. But now the Marriage Act itself has actually prescribed that a male, if he wants to marry, he should have completed the age of 21, and if a female, if she wants to marry, she should have completed the age of 18. Well, that is the latest position with regard to marital relationship between individuals. That what qualification they should possess and what are the conditions they have got to fulfill in order to get themselves legitimately and legally married. Well, that I have said. Now, restraint on marriage. Any agreement which restrains a person from marrying Even you cannot compel a person to marry. Now, in this connection, there are two cases which I want to tell you so that you can understand it very nicely. That is, Pierce versus Lowe and Frost versus Knight. These are the two cases. If you remember this much, that is more than enough. Now, so far as Pierce, P-E-R-S, Pierce versus Lowe, L-O-W, Pierce versus Lowe and Frost versus Knight. These are the two cases. In Pierce versus Lowe, please understand the illustration carefully. B enters into an agreement with A. B is a lady. He enters into a contract. He enters into an agreement with A, who is a male, stating that A should not marry anybody else other than B. That is the agreement. Just understand it properly. B, a lady, enters into a contract with a gentleman A that this A should not marry any other person other than B. It so happened that A married somebody else other than B. Then B filed a suit for damages. The court said you are not entitled for any damages because there is a restraint clause, there is a restrictive clause under the agreement that A cannot marry anybody else other than you, which is considered to be a restraint on marriage. But in Frost versus Knight, the agreement was of a different type. In that particular case also, B entered into an agreement with a gentleman, that in case A marries anybody else, A should give damages to B. This was enforced. Why? Because there was no restraint. What restraint? That B has entered into the earlier contract that A should not marry anybody else. That particular condition was not there in the other Frost versus Knight in that particular case. In case A marries anybody else, damages should pay to B. Well, that was allowed. So that is one other aspect which I got. And then dowry. Dowry, you see, dowry has been prohibited. Anti-dowry, Dowry Prohibition Act and all those things have come into force. So you cannot actually pay dowry for the purpose of just marrying. But unless customs permits, see, customs in so many religions, they permit, in Tamil Nadu they call it as parisam, and in Muslim law, davar has got to be paid and all that. That is recognized by custom. That is not affected by law. But if you enter into an agreement specifically that certain amount by way of award should be given, or by way of price should be given and all that, or dowry should be given, well, that is not encouraged. So, anti-dowry system that has come into force, and Dowry Abolition Act is very much popular. Now, there is another interesting case which you can refer to the book and understand it. Supposing A is already a married man. He enters into a contract with B, an unmarried woman, and B says that in case A happens to divorce his wife, namely original wife, he should marry B. So for the purpose of enabling A, this woman helps him to pay court fee and to take care of all the expenses, legal expenses, for the purpose of getting divorce from his wife, Mrs. A. And then after getting divorce, Mr. A refuses to marry B, because she has actually, in fact, she has provided money, all assistance and all that. After getting the object achieved, now A says, I will not marry. Can this agreement be enforced? Definitely not. This itself becomes, even the marriage that has been nullified on account of this will be invalidated by the court and set aside. So, this type of restraint on marriages, it is not actually authorized and it is not recognized by law. Well, marriage, restraint on marriage. Then marriage, next automatically, what has got to be studied? Parentage. Marriage first and then parentage. Restraint on parentage. Generally under law, Court and Wards Act, and you have got any act, Hindu Act, Adoption Act and all that, Guardian and Wards Act, and so many enactments have provided what they have provided, that is Guardianship Act. Now, till the child completes the age of 5, the mother shall be the natural guardian. And after the completion of age 5, then father will be automatically, he can actually become a guardian. So this is the general provisions of law. Now, there are cases in Susaina Baker's case, wherever the court finds that mother's guardianship is not good or is not congenial to the boy, then, or a girl who is a child, then they can remove the child from the guardianship of the mother and they can appoint a court guardian to take care of the child, or they can pass order that the child be admitted in any school, any kindergarten school or any krishi to take care of the child and all that. So, it is always left to the discretion of the court. But however, let us see what the law has got to say on general principle. Now, you have got a famous case, that is Giddu Narayanaya versus Annie Besant. Annie Besant, you know, she was running a famous school known as Theosophical School. In this particular school, Krishnamurti, Jiddu Krishnamurti, later on he became GK, famous man, and another son, that is another his sibling, his brother, both of them were admitted by Giddu Narayaniya in this Theosophical School. Now, on account of admission of these two boys in the Theosophical School, the school actually sent them abroad for foreign education to London. Now, after the boys were sent to London for study abroad, this particular Giddu Narayana, who happened to be the father of these two boys, he filed a suit that the custody of these children should be given to him. He wanted that the children should be called off from London and their guardianship, and he being the natural guardian, and they must be actually entrusted to him back so that he can educate them personally. Then the question came up before the court whether this father who has filed a suit on a habeas corpus petition for the custody of both the boys, is it legal and is it valid? The court said, no doubt you can file a suit. The father has got the right of custody with regard to the boys. But in as much as the children are now studying at London, we cannot actually apply the Indian law to the transactions which are not applicable under English law. So, on this technical ground, this subject matter actually failed. See, the suit filed by the father for the custody of the children miserably failed. So, this you must have right of parentage. Then, the right with regard to conducting trade. Right to marry, right of parentage, right to carry on any trade, right of personal freedom. These are the four aspects which you should bear in mind. Now, right with regard to carrying on any trade or profession. Nobody can restrict anyone from carrying on any profession or any business or trade. This is guaranteed under the Constitution. Right to conduct any business, right to carry on any profession, that is guaranteed and granted under the Constitution. You cannot therefore enter into a contract, nor even a statute can actually be framed. You see, any statute which is opposed to Constitution can be declared as null and void, and it can be quashed. QUAS. You can be quashed, that can certiorari. You can file a writ of certiorari and you can pass that particular enactment which is opposed to Constitution. Then the other aspect is, any contract that is entered into by the parties must be authorized under the Act. So what do you now understand? Any enactment that is passed either by the state legislature or by the central legislature, parliament, or by the state, they are subject to the provisions of the Constitution. Any enactment. And any contract that is entered into by the private individuals must be subjected to the provisions of law. You cannot enter into a contract contrary to an enactment. So this broad aspect you should bear in mind. So, any person can carry on any trade or profession subject to the provisions as contained under the Constitution, as contained under the Act. So, you cannot enter into a contract imposing any sort of restriction with regard to carry on any business. In this, so every person has got a right to carry on any trade or business. But any restriction that is imposed on a person from conducting business must be reasonable, rational and conscionable. It should not be unfair and unconscionable. This particular aspect you should bear in mind first and foremost thing. Nobody can be restricted from doing business. In this connection, let us take up some case laws. First, you have got, first case law is with regard to Shaikalu versus Ram Sharan Bhagat. In this case, there was a person who was selling comb, that is for dressing your hair. Now, the comb manufacturers, they entered into an agreement with this wholesale merchant that they will not sell the comb manufactured by them to any other person other than the wholesaler. In economics, they will say monopsony. Monopoly is sole selling seller. He is enjoying the sole right to sell. Jurisdiction is actually given with regard to Bangalore and with regard to Coimbatore, with regard to Madras. So these are all the regions where a person has got a sole selling dealer, exclusive right to sell the articles. Only this person can sell it. That is why you are actually appointing an agent or a distributor for doing business in a particular area, and nobody can do business pertaining to that article in that particular area other than the sole selling agent. Like that, here, Shaikalu versus Ram Sharan, monopsony, sole selling purchase, sole buying purchaser, sole selling dealer, sole buying purchaser. So, everything that is manufactured should be sold only to him. What is the example you get? Can you, sir, illustrate by giving an example for monopsony? Yes, railways. Any wagons and rolling stones that are actually manufactured has got to be sold only to the railways, because railways alone can make use of this rolling stock, no other than the railways. Therefore, monopsony. This fellow entered into a contract with the comb manufacturers. They should not sell the combs that are manufactured by them to any other party. That is an agreement. Now, what happened? One of the comb manufacturers sold some of the combs manufactured by him to a private party. Thereupon, this sole buying purchaser filed a suit against him that it is against agreement. The court said this agreement itself is null and void because it imposes restriction on the right of conducting a business, right of doing business. That is the case of Shaikalu versus Ram Sharan Bhagat. The other case is Rajkumar versus Madhav. In that particular case, two persons were doing business side by side. Sari business, that is saris and textiles, they were actually selling. It so happened that A and B, they were doing business. Both of them were running the shop side by side. It so happened that B was not doing business as briskly as A was conducting the business. In fact, the business of A was considered to be more active than that of the business carried on by B. And not only that, B had incurred debts also, and he incurred liability in not paying the employees of his shop also. A entered into an agreement with B because A felt that he will be benefited if B's shop is closed for some time. He entered into an agreement with B. Look here, B, you are not able to do any active business and you are not also able to make profit. What I request you is, you better close your shop for a period of 6 months. You better close your shop for some period so that I can actually get all the customers to my shop and I will make profit. And on account of this profit, I will discharge your liabilities which you have got to pay to your own employees and other people. And then I will relieve you from all liabilities. Then you can originally start your shop. This B also believed A, and he entered into an agreement to close the shop. Then when this fellow never paid the amount and never discharged the liabilities of B, then B filed a suit. The court was rather surprised. There can be only agreement to open shops. Here is a case where an agreement has been entered into by a party for closing the shop, which is considered to be not according to law, not according to the rights that are conferred under the Constitution. So therefore you cannot bargain your right. You see, nobody can actually, even an employer cannot actually make an employee to forego his right, personal freedom. It becomes a bonded labor. But bonded labor also, some of the students used to ask me, I will tell you about that later. Now, so far as this particular case is concerned, the court said, you cannot actually make another person to close his shop. And then on the, no, definitely this is against law, this agreement is not valid, and you have got to actually reimburse the loss that the other party has incurred on account of your persuasion. It is a sort of misrepresentation. Then the next aspect is Coors versus Kolak Manufacturing Company. That's another case which is very common among people also. Supposing an employee actually serving in one particular firm. Now, can employers enter into a contract among themselves that an employee who is terminated by me should not be re-employed by you? Supposing I am Sreenivasan, there is an employee under me, and Shashank is also running another business. Now I enter into an agreement with Mr. Shashank stating that whoever is actually terminated as an employee by me should not be re-employed by you. You cannot employ any person whose services have been terminated by me. Is this agreement valid? Definitely not. You can actually enter into an agreement for providing employment. Can there be an agreement so as to deprive employment among people who are unemployed? Certainly not. So this is against law. This is a case of restraint on doing business. Then that is what is known as business aspect of it. Then there is a famous case, Maxim Nordenfelt versus Nordenfelt. There is what is known as what you call it as partial restraint and total restraint. Total restraint is void. Partial restraint is valid. I will summarize the facts of this case briefly as follows. Maxim Nordenfelt happened to be the manufacturers of ammunitions. Ammunitions means guns and things that are used for fighting. So, in a war and all the ammunitions. So, they were the manufacturers of ammunition. So, Maxim Nordenfelt entered into a contract to sell away his business to some X, another concern, who are eager to purchase this business from Maxim Nordenfelt. Now, Maxim Nordenfelt entered into an agreement with the prospective purchaser, stipulating two important conditions. One condition is that the purchaser of this right of ammunition should not carry on any other business other than business pertaining to ammunition. Number one. Second, he should not conduct business in similar, that is, in the same place and very adjacent to him. So you cannot actually do business in any other product with different patent. He should deal only the patents which are being sold by him, and you should not sell any other thing. In fact, under the MRTP Act, it is not considered to be valid. Can the manufacturer enter into a contract with the retailer that you should not sell any other product other than his own product? Any businessman would like to sell as many products as possible with different brands and all that. He is only interested in doing business. So here, in this particular case, the Nordenfelt and Company entered into a contract with the private party that he should not actually do any other business. That was considered to be a total restraint. But the partial restraint is he cannot actually do business in any other article similar to that of the brand mark which he has actually sold to the particular private individual. So that is valid. There is partial restraint is valid. If he is saying that he should not sell similar product with a different brand other than his own brand, supposing Hindustan Livers have appointed X as the sole selling distributor. Now is it left open to the sole selling distributor to sell other than Hindustan Livers products? Procter and Gamble, can they sell it? Well, that is not valid, because under the agreement they will say you are my sole selling distributor, but you cannot sell any other product other than this. That is what is known as, it is a restriction under the MRTP Act, Monopolies and Restrictive Trade Practice Act, that will attract the provision, because right to conduct business is. But this is for sometimes they may enter into a contract authorizing a particular medical shop to sell medicines of a particular nature, and they should not. That is valid because they have got certain infrastructural facilities. They don't want any other product to be actually mistaken by the general public for that, because they may actually, even for example petrol bunks, they may actually give the right to sell petrol to a particular bunk, and they should have all the facilities. You must have all the necessary infrastructural facilities and all that. Then only we will give the right to sell. Well, that is reasonable and it is permissible also. So this particular aspect, total restraint is not valid. You cannot do any other business, means that is considered to be bad. But you can do partially. You cannot do a business with regard to the similar product. For example, you take Nandini, they are the products of Karnataka government milk dairy. Now they say, when you are actually appointed as our depot agent for to sell Nandini dairy and products that are actually manufactured, but you cannot actually sell heritage milk or heritage butter, because you may actually adulterate both these things. Both Nandini and heritage products may be mixed and you can sell it. So in order to prevent genuine nature of the business, genuine nature of the product, such conditions are considered to be valid. Well, that is what is known as partial restraint. Partial restraint, but it should not be unfair and unconscionable. See, now you leave alone business. What about the trading community among themselves? Supposing there is a joint Hindu family, they are running business with regard to Arcanet. For example, the betel nut, they are actually Ashoka or so many other, you have got Rasikalal, so many products, they are selling betel nut powders. Now, the father actually who has been running the business, he is the sole proprietor and he was running the business on account of his labor and endeavor. This particular product has been invented and patented, and they are enjoying now the privileges of selling that. And now here the father actually expires. He has got 3 sons. All the 3 sons want to inherit the business and conduct the business separately, exclusively. Now, nothing prevents these sons from entering into an agreement that no son should actually, no brother, see, when there are 3 brothers, among themselves they can enter into an agreement stating that this particular place, Bangalore, the eldest brother can actually take up the right of selling these arcanets here. And so far as the younger brother is concerned, he can go to Andhra Pradesh, Bezwada, and he can sell. And so far the last brother is concerned, he can actually go to Kerala and Trivandrum can be chosen. So, this is not considered to be a restraint on trade, because from the point of view of proximity and from the point of view of prospects of business, nothing prevents the party from preserving trade secret. So supposing they enter into an agreement that the secrecy of the trade must be actually be protected, that so long as you are doing this business, don't teach the way in which the arcanets are got to be prepared and scented. Well, that is considered to be valid. That is the secrecy of the trade. Secrecy of the trade can always be protected and preserved by entering into an agreement. That is considered to be valid agreement. So, if you know this much, that is more than enough. That is with regard to restriction on business. Then, with regard to partnership firm, I will briefly tell you. Before partnership firm, contract of service, restriction on service contract. The best suitable common example I can give you is the doctor conducting a dispensary. There is a doctor. He has got a junior doctor who is actually learning the art of surgery and so on and so forth. Now, so long as the junior doctor is under the service of the senior doctor, there is no question of restriction. Supposing the junior doctor, after attaining sufficient maturity, sufficient experience, he wants to set up a separate establishment and he wants to set up an establishment. Can the senior doctor enter into an agreement with the junior doctor that he should not do business in the same place for a period of 6 months, so long as he is doing business? So whether this agreement, is it valid? We have seen in a mythological story about Ekalavya, where the guru got his thumb broken and then he took it so that this fellow cannot. But this type of agreement is not at all allowed nowadays. See, but it must be reasonable, fair, conscionable. Supposing the senior doctor says, look here, junior doctor, you cannot practice as a doctor near a proximity of 5 miles distance, 5 kilometers distance. You can go and actually do practice elsewhere. Well, that is considered to be valid. That is considered to be valid. It is fair and reasonable. You cannot do similar business for a period of 6 months, so long, and afterwards, that is also reasonable. So the court will actually take into account whether the restriction that is imposed on the agreement, is it reasonable, fair and conscionable. Depending on that, they will actually. In fact, there are some cases which have been distinguished. Herbert Morris versus Saxel B. In this particular case, what happened? A fellow who happened to serve under the management of a particular organization, he learned the art of preparing organization charts. He used to prepare charts and learned the secrecy. Then this particular company entered into a contract with him. That is in the case of Herbert Morris versus Saxel B. That you who happen to be our employee, in case you leave our employment, you cannot prepare charts. You cannot do this activity at all. Well, this is considered to be a restraint on trade, a restraint on service contract, restraint on service contract. Now, you see, if a person learns the art of learning certain skill and all that, you cannot prevent him from expending that skill and eking out his livelihood. You cannot totally ban and totally prohibit him from doing that particular profession. So here, Herbert Morris versus Saxel B, the person who wanted to draw chart for a rival concern, after leaving the job, as long as he is your employee, you can prevent him from doing that job. But when once he has resigned or he has been terminated, you cannot prevent him, you cannot impose this prohibition that he should not do the same job in order to eke out his livelihood. You see, for example, you take government service. So many people are government employees. So long as these people are government employees, they are prohibited from doing business privately. For example, take a government doctor. A government doctor cannot practice privately and they should get permission. If the doctor gets permission to privately practice, then it is all right. Even in the colleges, you will find if any lecturer who has actually been admitted in a college as staff among the teaching staff, he cannot actually conduct private tuition without the permission of the management. That is general, that is what is known as professional ethics, professional code. So, any sort of restriction with regard to contractual services. Jackson versus Oaks, that is a case where a person was actually manufacturing caps, that is for ladies' caps, ladies' hats and other products, So, there was a contract, there was an agreement between the manufacturer and the employee that the employee should not set up business of a similar nature for a period of so many years and within a proximity of 5 kilometers distance. when this agreement was placed before the court said this is considered to be very reasonable and conscionable and fair. So the court allowed that restriction. So wherever the restriction is found to be very beneficial and it is not affecting the person who has been originally conducting the business, and if it is not going to affect the business of the person who has actually permitted the employee to set up a rival business, well, so long as it is not going to affect the main business, then the agreement is considered to be not bad under law. So that is with regard to contractual service. Then let us take partnership. Under the partnership agreement, you must remember 3 important sections. That is section 11, section 16, section 54 and section 57 under the Partnership Act, 56 and 57. Now section 11, you see, when a partnership firm is conducted, a firm cannot be conducted without partners. So how many partners there can be there? Now it is 100. Now previously it was 20. See, under section 11 of the Companies Act, a partnership firm can have as many as 20 partners. More than the 20 partners you cannot have. There is a restriction imposed under the Company Law section 11. Now it is raised to 100. Now according to the latest 2013 Act. Now so far as partners are concerned, the partnership business, supposing a particular partner who wants to retire under section now first let us take up section 11. Now if a particular partner wants to do, in addition to the partnership firm, if he wants to do any other business not connected with the main business of the firm, then also he should take the permission of the other partners, namely co-partners, and then only he should conduct business. Now let us take for example, here is a partnership firm which is conducting textile business. They are actually textile business. One of the partners in that particular firm is conducting separately hardware business. Now, this particular partner who is conducting hardware business, he cannot conduct that business without the permission of the other partners, co-partners. Unless the other partners permit him to conduct hardware business, he cannot. Why? Because the interest will become divided. What will happen if anybody who comes to the textile shop conducted the main firm for purchasing textile products, this fellow will ask them, sir, if you want any hardware equipments, if you want any materials, doors, screws, cupboards, glasses and all that, please come to my shop, and he will be only concentrating on his business, losing interest with regard to the partnership textile business. So you will get divided interest. So that is why they should actually seek the permission. If any other partner wants to conduct any other business other than the business of the partnership firm, he should. If I am speaking any other business, similar business, definitely it is detrimental. Side bottom versus Kershaw, that is under company law. Even a shareholder cannot conduct any business similar to the business conducted by the company, because you see the business of the company will become affected. Likewise, in a partnership firm, when they are conducting business in dairy product, if a particular partner individually he wants to conduct a proprietary business on dairy product, definitely he will be actually trying to entice the customers who are coming to the firm for doing business. Therefore, that is considered to be invalid. So, that is under section 11. This is under section 16. Similar business also cannot be conducted. Then section 54. Sometimes that is the partnership firm itself may sell their business because their business has become dull. And then the purchaser, nothing prevents the purchaser who purchases the goodwill of this particular firm from entering into a contract with that firm who has actually sold their business, that you firm who have sold the business to me should not carry on business under the your old name and style, because now that I have purchased it, and you should not represent yourself as partners, and you should not entice away the customers who are actually coming to me. So this is considered to be reasonable. This cannot be considered as invalid. Sometimes section 57, that is with regard to purchase of goodwill. Section 54, in anticipation of dissolution of the partnership firm, some person's prospective purchasers of this partnership firm, a person who retires, supposing under Section 27, a particular partner wants to retire, he wants to exit from the partnership firm. Nothing prevents the existing partners from entering into an agreement with the retiring partner. You retiring partner, you shall not do business under our name. You can have your own name. You cannot do business under our name. You cannot entice away our customers. So we will permit you to retire from this firm, or we will permit you to exit from this firm, so long as you agree that you will not represent yourself as a partner to the outside world, and you will not actually make use of our name and project yourself as a partner continuing here, and you should not entice away our customers. If these conditions are there, it is considered to be valid. So also in the case of dissolution, if any partner in anticipation of dissolution enters into a contract that agreeing not to actually represent himself as a partner, not to entice him, well, that is considered to be valid. So these are the things which you have got to bear in mind. Then personal freedom. Personal freedom, you have got Harwood versus Miller's Timber and Trading Company. Now, freedom of individuals to enter into any contract as they like is laudable feature. But then this personal freedom sometimes is exploited by businessmen by taking advantage over the poor and unemployed and illiterate laborers. Now, here in this case, Harwood versus Miller Trading Company, in this case, a borrower from a money lender secured money and agreed with the money lender that he would not change his address, his employment, and his job, and all these things. Let us put it humorously. Here is a case where a borrower has borrowed money from the money lender. Harwood versus Miller Trading Company, in that particular case. Now, this borrower enters into an agreement accepting to the conditions imposed by the lender that he will not change his address, that whenever he gives any increment in his income, he will inform him, and he will not actually expand his family. What a great restriction. See, expand his family means he cannot have, he has got to seek the permission for expansion of this family also. So this is considered to be a restriction on bonded labor, a restriction on his personal freedom. In other words, you call it as a bonded labor. So many people are employees and they go in serve in quarry premises where they actually sell themselves, and then they agree to whatever conditions that are imposed because of that penury conditions and poverty stricken stage. On account of that, these people, they sell away their rights. Well, this is considered to be a sort of bonded labor. Then you have got yet another case, that is the case of this Rama Sastri versus Ambalagaran. This is another peculiar case in which the borrower borrowed money. He borrowed money and the agreement was the interest has got to be paid on an exorbitant rate. The agreement was so drafted that the principal cannot be wiped off. He has got to actually serve towards, instead of paying interest towards principal, he has got to serve under an employer, and then going on serving him, the agreement was so made to such extent that the interest will never get completely settled. The interest will never get extinguished. So, to that extent, the agreement was manipulated and drafted. The court said this is a clear case of bonded labor. Then, one another question most of you will ask me. That is a case where a particular firm, particularly this arises with regard to computer programming and communications services, communication service. So here, whenever this agreement is entered into by the employer actually, in order to give training on sophisticated equipments like computer and other sophisticated missions, they are actually deputing the employees to foreign countries like Germany or USA or Australia and so on and so forth. So when they depute a person and he gets training in those places and gets knowledge and expertise knowledge he also derives and then comes back to the firm. Is it left open to that particular firm who has engaged the service of that particular IT industry employee that he should serve that particular firm for a period of 5 years? This naturally happens. When a person is recruited, sir, you see, these people, they say that I should remain there because they are prepared to train me. Even here itself in India, or they will actually give training by sending me to America or by sending me to Germany and all those places. But after return from those places, I got to serve here for 5 years. Is it a valid agreement? Is it conscionable? Is it fair? Well, that is fair to a certain extent, because that you are going to serve at least for a period of 5 years, they are incurring liability on account of your training and education. Don't you agree? See, here is a firm, they are spending money on account of you by deputing you to get training in foreign places where you have got to stay there, study, get yourself experience, and not only that, your knowledge also gets improved, your position also gets enhanced technically, professionally and whatnot. So here they cannot prevent you. Any sort of agreement that prevents you from leaving the firm and then getting into a better employment. Everybody would like to advance and progress with regard to his financial status and position in status. See, status with regard to his position. So, nothing actually prevents. But here, what you should notice is that the firm that has recruited you has incurred expenses by sending you to a foreign place and by educating and all that. So, nothing prevents them. In case that if you want to seek employment elsewhere, you have got to pay a certain amount of money towards compensation for leaving this job before the period of 5 years fixed for you. Not only that, you must understand here, you have been well trained. It has taken so much of years for the particular firm to train you up and to teach you, to make you to become an experienced staff and all that, to provide you all facilities and all that. Once again, you must understand, they have got to recruit another person in your place. They have got to give an advertisement. Once again, they have got to give him the necessary education. Once again, the training has got to start and all that. Don't you think this involves a lot of expenditure on the part of the company? So, nothing wrong. But this type of restriction, that you should not leave the firm within a period of 5 years, that of course that is a restriction. That is definitely is more or less it is a bonded labor. But they should actually provide alternatives. That is where you have got to given the option of actually paying compensation. But nothing prevents reasonable period, because unless they find an alternate person, you have got to serve there, because you cannot just leave the business abruptly and it will be at loss for them. Therefore, these are all very reasonable and it is fair. So, if you understand this much, that is more than enough. Thank you.